That's another thing people don't think about in divorces, which guess what? Means more money you're paying out of your pocket every month and can also affect your marital settlement agreement because we have to look at that. Let's say me being the exiting spouse, why would I want to do something like this? My name is Michael Lux. I have been in the banking real estate community in South Florida practicing since 1982. Born and raised in Miami. I am a native. I specialize in doing private consulting, working harder to do situations. I am a direct lender. Our company, one of the companies I'm with, we are delegated to underwrite for, most people, normal mortgages, government mortgages, Fannie Mae, Freddie Mac, but I'm a certified divorce lending professional, one of the few in the state of Florida, and I specialize in creating strategies that can keep both exiting spouses happy and as happy as possible, I should say, but getting them what council has decided what their MSA or their marital settlement agreement states. So in my particular situation, since I have worked the real estate end, I'm not an attorney, I'm not a financial planner. However, in order for the divorce process to work properly, especially in our state where we are the fifth leading state in divorce in the country, unfortunately, 70% of those divorces involve real estate, and it's usually the largest marital asset. So if I can get in there early enough with counsel, because you have divorce law and then you have lending law. So we have to make sure that they work together so that the outcome is what everybody wants as far as division of marital assets when it comes to real estate. So that's basically what I do.
And then to move on from the divorce, you also help people get new loans, whether they had a mortgage with the spouse or they want to move forward with something that they're still on the mortgage. You would be able to help in devising that marital settlement agreement so that doesn't affect them in the back end, right? To get the lending.
Right. So when we go into some, and you hit it right on the head, we can't, at least the approach that we look at it, the holistic approach, is basically that we don't have to just create a strategy to satisfy what we need now, but we want to satisfy the divorcing spouses in the future. Like you said, it's not just for now. We have to create a strategy. And sometimes the initial strategy isn't palatable for one or another because it's tough. So, for example, in most situations, three things will happen. Either A, they're going to decide to sell the real estate. B, one of the parties will buy the other out in cash. Or C, which is where I come in more, actually I could come in through all of this, is when there's an existing mortgage on the marital property. And when I say marital property, it's typically the homestead. So in a case where, let's say, for example, the exiting husband is going to be relinquishing the marital home to the soon-to-be ex-wife, what happens a lot of times is marital settlement agreements are prepared, judges approve them, and it basically says, I, Michael, am going to be giving Sarah our house that raised our children in. And for that, though, Sarah has to get my name off of the mortgage because we presently have a $300,000 mortgage on the property that my name's on, as well as the other exiting spouse. And it sounds really easy, okay, yes, Sarah's got to refinance, and usually, hopefully, there's a specific time period given for that, and that's where we get involved also. Because sometimes the exiting spouse is fine, but the spouse remaining in the property is not going to be able to qualify for the existing mortgage that's on the property. And everybody thinks, oh, yeah, no problem. Sarah's going to stay in the house. She's going to be able to manage the payment, which is fine. But how is Sarah going to qualify? Because there is something on a mortgage that's called a due on sale or transfer clause, which means whenever there's a transfer of division of property, that mortgage needs to be paid off. So, unless it's assumable. So if the loan is fully assumable with no qualification, that's one option, but that's very rare. It means Sarah just signs an assumption package, move right into, well, you're already in the property, you assume a loan and everything's good. The next thing is assumption with qualification. It may be a loan that has the feature that Sarah can, and you can ask for this even though it's not on the loan, that say, hey, look, I'd like to keep this loan. Because not only is about qualifying for the new loan, the reason why they want to keep that old loan is because that's a nice 3% mortgage loan and rates now are
Right.
over 6%.
And it's
So we
very
have,
typical. Yeah, it's very typical
it
about what
is,
you're talking about.
being counsel, it's one of the things we need to know because it affects the cost. So if you're just thinking that it's going to be tit for tat and we're going to replace a 3% mortgage with another 3% mortgage, that's not going to happen. And the spouse that's going to remain in the property, their debt service is going to go up substantially too, which can also affect the marital settlement agreement. So what we want to do is look into that, and hopefully those two remedies can be done. If not, then the spouse that keeps the property would have to qualify for a new mortgage. So a lot of times that's done without much consideration for the future because they just assume that since the spouse remaining in the property has great credit, let's say for example purposes, it's the wife, and she's been at home and she's a teacher. She doesn't make a great deal of money because she's been taking care of the children, etc. It's going to be challenging for her to qualify for this new mortgage all by herself, especially when sometimes there's even an equity buyout. And when I say an equity buyout, meaning I say, okay, Sarah, you can stay in the house, but you've got to give me an extra 50 grand.
For the
Well,
50% or whatever percentage of the
whatever,
marital estate. Right.
whatever, exactly.
Right.
So whatever's negotiated on behalf of the exiting parties, and that's why my job is to hopefully get in there early. Because getting in there early, I could say, and you've got the division of assets, that's your guys to decide, but how to devise them is important. So for example, a lot of folks think, okay, Sarah's walking in there and all Sarah's got to do is refinance that $300,000 debt. Shouldn't be a problem because part of the marital settlement agreement is I'm going to be giving her $500,000 as a lump sum settlement for whatever reason. Most people think that just because Sarah's got 500 grand in the bank and got a 700 credit score, attorneys as well, that she's not going to have a problem qualifying. The problem with the qualifying comes in is that $500,000 that was just that your settlement indicates you're going to get, unfortunately, is not income. So we can't use it as income. The only thing we can use as income, there is a loan program, which is basically a non-conforming mortgage, not the stuff you see advertised with low rates. We can get a mortgage, and sometimes we do, which is based on the depletion of the assets. But that's not, like you alluded to earlier, that's not thinking about the future. We want to get a good loan that's going to keep this homeowner in there for a long period of time. What a suggestion may be is instead of if I'm there before that marital settlement agreement is prepared and put in for approval, rather than giving Sarah, the remaining spouse, that $500,000 to her directly, maybe putting it into and again, this is why we have to bring other professionals in, such as financial planners or asset managers, to say, okay, instead of giving them that $500,000 lump sum and just making a check payable or a wire payable, why don't we create some sort of a revocable trust? And again, I'm not an attorney, but by creating a trust, when that's revocable, those funds are now, the trust can actually pay Sarah a monthly amount. So
As
Sarah can get 200 up front, 300 in a trust, and that 300 trust gives her a check for 10 grand every month.
right.
Way us mortgage companies look at it on the delegated end, the government, the best type of money. We have to see it come in for 3 months and then continue for a period of at least 36 months.
Excellent.
Now, we can do that with the Federal Housing Administration, but that's not the most desirable loan. It's not a bad loan, but there's mortgage insurance. The rates are a little lower because Fannie Mae and Freddie Mac, the other conduits for loans that we want to put our clients into, they changed those guidelines and now they want to see income coming in when it comes to a trust for 12 months. So something I need to know, guidelines and changing guidelines. So now, in lieu of maybe setting up a revocable trust, sometimes, again, we involve a financial planner or whoever manages their assets, say, why don't we put it into some sort of a fixed annuity? And again, I'm not an investment counselor, but a fixed annuity means we could put a portion of money into an account and that annuitizes or makes monthly payments for the lump sum. So in other words, now, and what I'm getting at now, is now I have a source of monthly income because that annuity is going to run for a long time. And if it's an annuity payment, all I need to see the recipient getting that annuity payment for a period of 3 months and then continuing for at least 36 months. Those are the guidelines. There's no way around that. So
Right.
we structure these settlement agreements up front early enough, and why would, let's say me being the exiting spouse, why would I want to do something like this? Well, first of all, it doesn't make any difference to me because I'm still stroking hypothetically a check for $500,000. But where it comes out to me is where I can benefit is, let's say I would be paying alimony. Let's say that it looks all directions are I'm going to be paying alimony. Our kids are older, so I'm looking at an alimony situation of several $1,000s a month. Well, if that happens and I still give you just that lump settlement, then two people are hurt. You can't qualify with the lump settlement, and I can't qualify because there's a lump settlement and alimony. Because now when I go to buy a new house, guess what? That alimony is held against me.
That's right.
By the same token, if that alimony, instead of me making an alimony situation, again, we form some sort of a trust or form an annuity structure that doesn't show me making that monthly alimony payment. Now it allows me to go off and qualify for my new home because I'm not showing that alimony.
Uh-huh.
Even though the trust has or the annuity has the money, I've already paid them.
So they
There's
look at an alimony as a deductible from the gross income that you make. It's taken off, and
most
because they look
certainly.
at the net. What other incomes are also deducted from that gross income
If it's a
that could
veteran,
affect
and
them?
that's why it's important if one of our divorcing spouses is a veteran, in veteran mortgages, okay,
Yes.
with VA, the Veterans Administration, uh, part of that GI Bill allows a veteran to get favorable financing.
Mm-hmm.
However, and they're
That's
great
right.
loans because they are assumable. So if that veteran is involved, to answer your question, what we look at is childcare. So
Okay.
if I'm involved early enough and I know the exiting spouse or the spouse living in the property is going to be paying for childcare, and
Okay.
that's aftercare, whatever it may be, unlike conventional loans, Fannie Mae, Freddie Mac, even the Federal Housing Administration, they don't count child care expenses against them. But a veteran, for a VA loan, it is counted against them. So
Interesting.
you have to keep that in mind to say, maybe let's not go that route and do a settlement route or a trust route or something.
But the VA is a little bit easier to get the assumable qualifying loan. Like
Yes.
they're a lot
That's
easier, right?
so let's say me and you were getting a divorce and you're a veteran and you're staying in the house and I'm a veteran. Or let's say you're not a veteran. I'm the veteran and the loan was in my name. The way the VA loans work, you're exactly right. They have a form of assumability towards it. If you are a veteran and I'm a veteran, then easy peasy, you can assume that loan straight up.
Okay, great.
If you're not a veteran, you
Hmm.
can still assume that loan. However, I still remain liable for the debt.
Interesting. Well, only in the back end, or does it show when, is it going to affect you when you go to get a new loan? Because now you want to, let's say for example, because
Mhm.
I know you could reuse the VA loan over and over as a veteran, but if you go into getting so you're still responsible, then you want to get another home using your VA loan. Are you going to be able to do that or no?
That's a great question. Yes and no. If the way the guidelines work, is if my name is still on it and I still have a contingent liability. As a matter of fact, if you don't pay, I still got to pay
For the assumable, yeah, for the
for the
assumability.
assumable part because you're not a veteran.
Okay.
How when I go to purchase my new home,
The
okay,
VA loan.
with a VA loan, the catch to that is I have to be prepared to show the VA that you have made 12 consecutive payments
Okay.
on your name alone. That's why
Okay.
it's so important. Not, I see a lot of these divorces and they create, so to speak, divorce accounts. So
Yeah.
we're going to have a Mike and Sarah divorce account where Mike deposits X amount of dollars every month, and that's where the mortgage payment comes out of. Big no-no,
Right.
because in the mortgage business, if I see the ex-spouse's name still on that checking account, it's not your payment, it's both your payment.
Well, in divorce law, what we have is very early on, we can get temporary spousal support and temporary child support as well, and that includes the child care. So if we do this early on with a certified financial planner and a certified divorce lender, finding out all our knowledge about what particular loans are out there and what we were trying to do in the future, on the temporary side, they can start paying because a final divorce could take up to a year to go to trial or to settle. So, but immediately they have to continue the status quo. However, if if the parties are really forward thinking and they really want to make something out of this, then that temporary could actually go into, like you said, some kind of annuity structure or into a revocable trust. And then they can start, basically it's a win-win for both sides, right?
Yes, and
And that would actually be included, even if it's a temporary order and not a permanent order that they've been showing the 3 months. Correct.
exactly things you can do besides a temporary order. And you had mentioned getting a certified planner involved as well, financial planner. You could utilize what's called a quadro or qualified related divorce domestic order.
Okay. Yeah.
But that would allow a temporary, in other words, you can take part of my okay for now.
Right.
The beauty is because using that quadro, you do not have to pay for early withdrawal fees, which are steep.
Right.
You do have to pay taxes on the amount that you withdraw. So it'd be my 401k to you because, like you said, this process, even if it's collaborative on the divorce end, could last quite some time. This allows one of the spouses relief during that time.
Right.
And that's important not only to keep things afloat for now, but to make sure that things go afloat, like you said, during the divorce and after the divorce, because we
Yeah.
want to make sure that not only is the spouse keeping that marital home going to keep it, but she's got to be able to afford it, and because we don't want to set anybody up for failure. And I know a lot of exiting spouses don't like that, but you know, we want what's best for everybody. And sometimes, let's say, for example, in my particular case, when I got mine, you could, if there's a mortgage on the property, I could say, hey, look, just keep paying it. It's going in your name. And now remember I mentioned before a due on sale or transfer clause on the mortgage. So even though there's an underlying mortgage on that house, and yes, the mortgage states that it must be paid off when there's a change of ownership, which there would be, because I'm taking all my interest and putting it to you.
Right.
But I'm saying, hey, look, I'm still going to be on the hook for the mortgage, and I don't mind that. You're there with my children or whatever it may be. I'm okay with that still being on my credit report. I don't need to qualify for another home, or I'll qualify with that payment on there. There's a little act, I believe it's called the St. Germain Act, whereas counsel can actually write a letter to the mortgagee, the mortgage company who has the existing mortgage, and say, even though there is a due on sale or transfer clause, this particular act will allow the remaining spouse to stay in the property without her having to refinance. You know what I mean?
Yeah.
Again, now you get to keep that nice 3% mortgage. Yes, I'm still on the hook. I'm an exiting spouse, but I don't mind. I
Right.
don't care. I have a good relationship. And that does happen, where you say, okay, look, just keep the house, just keep making the payments.
Hmm.
Either give me an equity buyout, pay me some money, or maybe not. Maybe I'm still paying you more money. That all changes, but you really want to keep that nice 3% mortgage. Another thing you want to keep is you want to keep your homeowner's insurance. That's another thing people don't think about in divorces. That when they switch homes, that insurance is going to stay the same. A lot of times that policy is just in one name or both of our names. When you have to renew a policy, and insurance is tough in Florida,
Yeah,
they're going to re-underwrite you again, which
right.
means you have to possibly change policies, which guess what? Means more money you're paying out of your pocket every month and can also affect your marital settlement agreement because we have to look at that. What is this spouse going to be paying after the marriage is dissolved? So those are things that are often just gone by because attorneys are, and even good attorneys are focused on that marital law and what they need to do, which I don't. But that law is different than lending law. So if we
Absolutely.
get together early enough, we can create a good strategy.
Yep, absolutely. I mean, your input is invaluable because you can stop a lot of things from going wrong and you can look at a lot of things from all the years of practice that you have. They don't teach the stuff in law school, so you're right. Like you do want to bring in these professionals, lending professionals, financial professionals early on, especially if you have a large estate or you need to get creative or someone's hurting or you want to refinance and you want to lend, get another loan out and yeah, so
It is important, and getting it up front is important. I mean, little things that I bring to people's attention, such as escrow disbursements. So let's say me and you are in a property and you're remaining with the property. I'm going to pay off the mortgage, or the mortgage will be paid off, and then you're refinancing, or you just have enough liquidity to pay it off. Well, let's say we're living in a couple $1 million house in Coral Gables, and our escrows, it's October, and we've got $70,000 in escrows in that escrow account at the bank. That bank gets that paid off, and even though I'm the exiting spouse, that mortgage is in my name. Who do you think that escrow check is going to? It's going to me. So we have to make sure. I always tell counsel, I say, hey, look, we are paying that off, and that's going to be refinanced. But theoretically, is all of that escrow money, does it belong to one or the other? Should it be split divisibly? Should it be, that's for you guys to decide the divisibility of it. But there can be quite a substantial little asset there, whether it be, it's relative, whether it's 5,000, 10,000, or 100,000. But typically people don't think about that. And then that check just goes back to me. And let me tell you, in most cases, you're never going to see that check. It's going in my bank account, so, and that's just the nature of the beast. So if we address that up front, make sure that's part of the MSA as well, the marital settlement agreement as well. When the escrow check is dispersed for what's left over, who gets that money?
yeah, absolutely. And up to what point are you now transferring the property? Because you also want to say the mortgage and interest up to this date are also going to be paid from the spouse as well.
Who?
Another thing, what about prenuptial agreements?
Oh,
Like,
um,
yeah, it says like, would you want to be a part of that? Could people like want to
if
say
it involves real estate, I could get involved with that. And that's very common. You're seeing a lot more prenups now
a lot?
than
Yeah.
before. It is important because when a divorce is filed, it's a lawsuit, it's a type of a lawsuit. And basically there is the legal here, but an atros, a temporary restraining order on selling any real estate assets that either party may own without consent of the courts. Typically that's how it works, even before the divorce. And that prohibits uh,
Yes.
from getting rid of assets without real estate assets, because it's one thing in this, and I'm talking about the state of Florida. In the state of Florida, when it's our homestead, you automatically have each spouse has an undividable interest in the property. But when it's non-homestead property, a lot of times that, even though, let's say I bought 10 apartment buildings before we got married 10 years ago, they're my assets. On paper, they belong to me. But is part of that asset possibly construed as being yours? That's for, again, judges and attorneys to decide, because If I bought those properties 10 years ago for $1 million, okay, it's my $1 million asset, but we've been married for 10 years. And a lot of times the value of those properties, let's say now they're worth $10 million. The first million may be my asset, but that next 9 million may be construed as a marital asset.
Yeah, well, the law kind of says if there was a pay down in the principal amount of the mortgage with marital funds used, this is without a prenuptial agreement being signed beforehand, then yes, you're absolutely right. There will be an equity stake of the non-owning spouse of everything owned during the marriage. And also, if they put labor or if they invest money on major repairs, that can also be construed as some kind of equity interest as well if they're using marital funds.
Important. That's why it's so important to seek a real family attorney for people because they need to know those things. And then back to your question on the prenup,
Right.
those are some things that have to be considered because many people think, and an attorney who's not familiar with, maybe a family lawyer is not that familiar with real estate distribution and real estate law, he may need to know that, everybody thinks, okay, yeah, I owned this property before. She has nothing to do with that. Well, if you have a prenup, you could, correct me if I'm wrong, in that prenup, you could say whatever I owned before you is mine and all mine, and whatever we own afterwards is ours, or whatever.
Yeah, and keeping out any marital labor done with it, any improvements, any investments, any marital money used towards that pay down of the mortgage as well. You can waive that in a contract. So, yeah.
Right. There are cases like I had one of my closest friends, his son, who I've known, he's a dentist now, and I've known him since he was born. He called me, 2 months before his wedding, and he said, Mike, I need you to refer me to an attorney. I need to get a prenup done. I said, get married in 2 months. First of all, not many attorneys will handle that because what people don't realize is if it does go up later on, I guess you would, being that close to being married, like I told him, it would almost be a pressuring thing. And, again, talk to attorneys before you talk to me, but you may want to have a little more ahead of time when you prepare a prenup, 2 weeks before you get married. So those are things they need to know up front, that you just can't come up with a prenup. And then, of course, there are postnups. So a lot of times, like you said, even if things are hunky-dory in a relationship, there may be a
After
postnup.
they're married.
Yes.
And then they
And
want
you
to either change the prenup or get into some sort of nuptial agreement. That's a postnup. Yes. Just, yeah.
do you see more postnups now than before? Is that something? I know I see more.
I'm seeing a lot of prenups right now. I do get a calls, yeah, a little bit of postnups that may be picking up a little bit, but just barely.
I like the prenuptial idea. It makes life a lot easier, but I could understand some people be reluctant to do them, So, but on my end, that's the first thing I ask them is there a prenuptial agreement? And
Right.
who prepared it? So that's important because those prenups that these guys do on the dining room tables, on the back of a Denny's napkin,
Yeah, rarely enforceable.
So,
If it's vague, you don't have the right terms, they don't really consider those.
see, and that's something I know nothing about, but I know one thing. The one thing I tell people they should do is they should call a lawyer. It's because there's so many parts of the law, and they should consult with a reputable local lender that is used to dealing not only with these type of assets, with these type of loans, and with these type of situations, because it's unique. Most realtors, when I teach this class to the boards or to the Florida bar, to a group of attorneys, the realtors and everybody thinks, oh, this is the gold mine. We love the divorcing business because we get a twofer or a threefer. You got two people, they're leaving a house, they're going to list that one and sell it, and they're each going to buy their own separate ways.
Yeah, and
It don't
speaking
work
of
like,
which, you do teach. You want to talk a little bit about that?
mm-hmm.
Where and what are you teaching these days?
Oh, Lord. I'm a senior faculty member of Florida Realtors, a junior faculty, just a newbie with Florida Bar. When it comes to Florida Bar, this is what I teach, the intersection, so to speak, of real estate and divorce. Because you could be a great attorney, but not, again, know the lending side of the laws that affect the laws that
So
you're
where does
basically.
someone find you on the Florida bar CLEs?
It's through different organizations. So let's say the Coral Gables Family Law Chapter has their monthly meetings, or they want to bring me in to offer a group of attorneys, a large firm, offer them this class. And I think it's a two continuing education course. So the attorney gets their required continuing education credits. So they can either find me, but it has to go through. The Florida Bar doesn't put it on themselves. It's kind of like with Florida Realtors, even though the curriculum is approved by DPPR, even though the curriculum is approved by Florida Bar Association, Florida Realtors, it's the local boards and chapters who need to organize the classes.
Okay, so you only do them live. You don't do them
I
recorded
don't, yeah, I told you before, I used to do them via Zoom,
Huh?
and um, it's I just don't have fun doing it. To be quite frank with you, I like people. I like being in front of people. Makes me feel good. I learn more that way. My attendees learn more that way. It's a win-win for everybody when we're in person because there's a billion things I don't know. So it's always good to embrace that new knowledge when I'm with people because when I'm in a class with 20 people live, it's so much better than having 250 on a Zoom.
Mm, and
It's just tough for
interesting.
me to talk and look at everybody, and it's not fun. I did it for a couple of years. COVID changed things, and then from that point on, Zoom became prominent. Well, now, of course, I could pretty much name what I'm at the point in my career where I don't have to do those Zooms. They just don't make me happy. And as far as, so for if an attorney wants to get this class, then sure, they could always find me and contact me through either social media. Look me up. I'm easy to find. If it's a realtor situation, then all of the boards I teach a lot. I pretty much shut down the second week of December, and I'm kind of all around South and Central Florida. So last week I did Naples, and next week I think I have one Miami, Boca, and then it's like Miami, Boca, West Palm, Orlando, Kissimmee, and other Naples. And I'll do like maybe 15 more classes. And then I take a month off, and then I start back up like the third week again for people who want my services to come in and teach their classes. So I could teach groups, and I have about 8 continuing education classes through Florida Realtors, and then I have 4 of my own continuing education classes that are DPPR approved as well. So, and a lot of those classes can cross over to certified financial planners as well.
Okay, and if a client wanted to discuss their case and bring you in with their attorney, what does that look like? They reach out to you, the attorney reaches out to you. Is there a cost up front? Is there a lot of documentation that they have to have ready with them? What would
No, that's a great question. I have a very thorough questionnaire that I use and I share with counsel and everybody. I mean, it's thorough. It also gets into a lot of the asset things you want to know as well. But if they want to we can either do it by a video call. I have no problem with doing it in person. We do not charge for, at least I do not charge for consulting, not in this capacity.
Okay.
Hopefully I will be of service it's all about working with the right people. And, so yes, we all have an agenda. We want to make money. We'd like to get some business out of it. But you know what? Probably at least half of the times that I'm involved, initially, I don't get any business whatsoever because we find a solution that doesn't require my services. Whether it's assumability, buyouts, a different structure. Sometimes I can do bridge financing. That there's different financing methods that I can use to hold folks over that'll accommodate the transaction. I mean, sometimes the person wanting to stay in the house, they're not in any sort of position to borrow money, and we have alternate methods of doing that as well. So we look at that. So if, however they get in touch with me, you had asked who gets me first. If I know the attorneys, there are attorneys who call me when they get these clients, and I come in at that point. Or people just I mean, I had a lady who called me yesterday. Interesting situation. Yes, Miss Elijah called me yesterday off an AI search. Who's a specialty lender when it comes to divorce.
Yeah, that's great.
So I'll come up that way.
Yeah.
Um, you know, I'm an open book. I have a website, michaellux.com, and I there's a little bit of social media there. I just it's not my forte, but it's everything what you see.
Actually had a call yesterday and they were like, well, we have a very expensive house and neither one of us is going to be able to afford it alone. So we're definitely going to have to sell it. So that would be very difficult if just the financing's not there.
It is, and a lot of times, like part of my class, I do one of the things I do is the importance of an appraisal contingency. Those of us who are in the real estate world, we look at appraisal contingencies sometimes when we make offers to buy and sell property. The property has to appraise for X amount of dollars. So typically, in divorce situations, um, they have to, of course, evaluate the estimated value of the marital home.
Hmm.
One way of doing it is by like an AVM from a realtor, like some sort of a marketing report, commutative marketing, CMA.
Like, yeah.
Um, Basically takes the comparables in the area and gives you an assumed value. That's one way. Another way is the county records, the tax assessed value. Some people still use that. I mean, it's not as accurate. It's typically very conservative, but I've seen that happen before. The most common way is hiring an appraisal. And typically, a lot of times, if it's nice when both divorcing parties agree on one appraiser. Then you just say, hey, we're going to hire this third party cat. He's going to give us a value, and that's what we're going to use as far as you distribute this asset. Sometimes, though, both parties will get an appraisal. Sometimes we get the first one and either side doesn't agree with it.
Right.
Then each divorcing party may get. And then you have me, the lender,
Yeah.
because I'm not going to look at either of your appraisers. So what happens, let's say we're using a valuation of, let's say, 600,000, because that's
Okay.
what the appraisers decided, the ones that you guys hired,
Right.
or one of the spouses, or both the spouses. And I come in there and as a lender, especially now where our market is sliding a little bit because there's a lot of time that goes involved. Time is a big factor when it comes to value. So right now, if I do the appraiser and now you want to refinance the property, pay
And
the
you're
spouse,
talking about a bank appraisal or a lender's
yes,
appraisal, a bank
a bank
appraisal.
appraiser.
Uh-huh.
So when we get that bank appraisal, now you guys agreed on a value of $600,000. Excuse me. You guys agreed on a value of $600,000. However, the bank appraisal, which is a complete third party, we don't even speak to the appraiser, we order it through a company. It's the
Right.
law. Comes in at 580. Well, now we can have a problem because now the person who's trying to refinance has got to come up with an additional $20,000. Or the loan is going to change the parameters of the loan since the property is worth less, the interest rate is higher, which means she may not qualify anymore. So what we recommend as
Hmm.
a lending professional in the divorce field is have your own appraisal contingency. What if the lender's appraisal comes in short? Then it is agreed by all parties, this is an example, that the price will be lowered to meet the lender's appraiser's valuation.
Yeah.
Or
And wouldn't you recommend that doing that in the beginning instead of spending time and money just with other appraisals, or that has to be tied with an application?
the
Like,
application belongs to whatever lender you use. So it used to, and
okay.
you could transfer. So what I would tell someone to do is, I mean, we don't know if you're getting a legitimate appraisal, then it should be the same. Theoretically, an appraisal is an educated opinion of a value of a property. So, and of course, they have to be licensed by the state, etc. But the problem is time. So even though the appraisal, let's say you recommended a certain appraiser to handle this for them, a certified master appraiser in the state of Florida. And he says that property's worth $600,000 now. But by the time we get into the nitty gritty of the equity buyout or the refinance of the property, 6 months has gone.
Yeah. Good point.
What happens with the valuation at that point in time? And a lot of times that's not recognized up front. So it's better to be proactive about that and put that contingency in there. So it says, hey, look, now if it appraises for more, what happens in that case? Typically it's, hey, everything's cool. But if it appraises for less, what's going to happen here? Because it affects the qualifications of the person, and it also can affect the cash required to assume or, refinance that mortgage. So those are the things where, why do they need a divorce lending professional? Yeah, because
Exactly.
we look into the future with those things, because we know it'll make your jobs much more difficult as counsel, and not to mention the poor folks that are actually going through the divorce. I mean, we got to think about them. It's all about the people.
Yeah, exactly. And, if more people come in amicably in the beginning and just saying, these are our goals. I want to leave her the house. I want to get something refinanced in the future. And then just being upfront about that, that would be the best bet for everybody. Just coming in and
Absolutely.
getting all your expertise up front. So,
That's why it's important to get the team together early and always keep that open dialogue. And when things get hairy, I'll back out. Just like I tell everybody, some things are just not a mix. You need to back out and not pick sides. And I'm there as I'm a hired gun to give somebody a loan, and it could be a private loan, it could be a conforming loan, it could be a number of types of products. But in the end, I have a relationship with whoever hires me to get them a mortgage. Until that point in time, I'm just giving them information so I can make sure that happens.
have you ever appeared as an expert witness to a trial in a divorce for any reason?
No, I haven't. I got called into one, and it never made it to trial.
I see.
And I think the feds just kind of used me and the council used me for free other than to pay for my parking because it didn't get to that trial point. But it's something that I always kind of wanted to do. But in this capacity, I've never been hired to do that or asked to.
Michael, it was wonderful speaking with you. You've added tremendous value to our podcast, and we look forward to helping out people and doing business and giving you a call, and even including the prenuptial agreements. I think those are very important. You can also add a lot of insight into issues they may have in the future and a funding or even promises to do certain things like assumptions or putting assumption language in there or something like that.
Very true. Very true. So it's all important. Again, and it's important to hire good attorneys to get, I tell everybody, you need a good team.
Yeah,
Everybody
absolutely.
has an important part in this process, you
Yeah.
know. So again, it's been my pleasure, Sarah. If I could ever be of any service to you or your clients, again, my name is Michael Lux. You can find me michaellux.com or Michael Lux. I'm an open book. I give everybody my cell phone number, my private number. I'm always reachable.
Yeah. Well, we're going to have your private number listed here. If you want to give it now, you can do that too, just so it's recorded for history.
It's 954-612-2690. And again, that is my real phone number. It's not a service or anything.